Welcome to The Next Fight. I'm Don West, National Trial Counsel for CCW SAFE. We're going to continue today with our discussion of a criminal jury trial. And today we'll talk first about direct and circumstantial evidence and then touch upon expert witnesses. I'm sure you've all heard the term circumstantial evidence. Usually it's used in a dismissive manner, like that evidence is circumstantial, it'll never hold up in court. A brief explanation, I think, is in order. Evidence offered in court is either direct evidence or circumstantial evidence. Both types of evidence are valid and can be used by itself or in combination with other evidence to prove the case. The main difference between the two is that direct evidence is evidence that speaks directly to the issue trying to be proven. For example, when a witness says, "I saw the defendant reach for his gun and shoot the victim just before the victim was going to hit him in the head with a hammer," that witness has just given direct evidence. If a lab analyst says the victim's blood was on the jacket of the defendant, that's direct evidence proving the presence of a certain blood type in a specific location. On the other hand, circumstantial evidence is evidence that in combination with other evidence can be used to prove a fact, but requires some inference. If the circumstantial evidence is strong, the fact is proven just as convincingly as if it was proven by direct evidence. For example, if a defendant claims that he shot the victim as the victim was trying to hit him in the head with a hammer, but the victim of a shooting in a self-defense trial testifies that he was at least 30 feet away, the presence of the victim's blood on the defendant's jacket is powerful circumstantial evidence that the victim was very close to the defendant when he was shot, and supports the defendant's claim that he shot because he believed he was going to be seriously injured or killed from being hit with a hammer. Likewise, if there's gunshot residue on the victim's clothing around the bullet hole, that's powerful circumstantial evidence that he was much closer to the defendant than what he claims. Expert witnesses. Most witnesses are fact witnesses who will be allowed to testify to what they saw and heard, but some witnesses will be allowed to testify as to their opinion. Once a witness is qualified to testify as an expert, that witness will be allowed to offer their findings as their professional opinion. For example, a fingerprint expert might say that in his opinion, whose prints were on the gun. A DNA expert might be allowed to testify whose blood was on the knife, and a medical examiner might be called to offer his opinion on the cause of death or the trajectory of a bullet. Those witnesses will be questioned the same way as any other witness, and the opposing lawyer will be able to challenge the credentials of the expert or the basis of the scientific technique that the expert uses. Thanks for watching. I'm Don West for The Next Fight.